Andrew, up, you left. I was going to tell you, I think they miss you over here because they haven't replaced you yet. I guess you're irreplaceable.
Jeff starts on Monday.
Oh, well, okay. They found someone. Sorry.
They found someone from Tarrant County. I haven't met him in person. I've only seen pictures. I think he's 12. His mom might drop him off at the courthouse. It's a young looking thing.
So you taking odds how long he'll last before everybody runs him over? Oh.
Yikes.
I'm teasing.
It depends. I have to see when he has a case with you, Stacy.
No, I wasn't meaning me.
Well, if not you, then John.
Maybe John. John's the mean one.
I am mean. I'll give you that.
He's
John is not mean. John is a most reasonable person. I have proof. He's about to call me about the pending Wesley Bunch plea that expires in mere hours from
right. I'm actually sitting down. That's why my sitting downstairs. That's why my thing says court. I'm headed over to talk to him as soon as we're finished and say, all right, dude, I need an answer.
Yeah.
There you go.
But you will hear from me.
Okay. Does anyone know what reiteration of the docket we're on now?
I just have Benny Newlish.
Yours, Benny Newlish is just a status.
Yes, Judge.
Okay, let's go ahead and do that one. Then I'll go to the pleas on Miss Martin's client, Mr. Winston.
Look how he just jumped right over me.
I know. I still got to sign the plea papers in Winston. So.
Oh, you know it's okay, Judge. I'm just harassing Mr. Perkins.
He's even here in the courthouse.
I know.
Okay, Mr. Newlish the fourth. Okay, this is D40636-CR State versus Benny Newlish the fourth. I have counsel for both sides present. Defendant is present. Oh. Apparently, I haven't let the court reporter in. Well, we'll try again. Sorry about that, Leslie.
Judge, that reminds me of the time that we were in court and as Leslie walked in the courtroom just for fun, you said, that'll conclude this hearing, and her eyes got really wide.
Yeah, she doesn't like me starting without her. All right, Leslie, now are you there?
I'm here, thank you.
Okay, thank you. Okay, let's try this again. This is D40636, State versus Benny Newlish the fourth. I have counsel for both sides present, defendants present. This is the first time, I think, Mr. Perkins, that you have appeared with your client in court. Is that correct?
Yes, Judge. I inherited this case, I believe, from a couple of attorneys, most recently, I believe, Miss Dennison. I had opportunity to meet with Mr. Newlish yesterday in the jail. While we're here on one case, I think he has 6 or 7 pending right now.
Yes.
I anticipate filing a motion to have Mr. Newlish evaluated for competency.
Okay.
And then once we determine that, we'll see where we're going.
Okay, so that I'm going to read the tea leaves. So you're at this point on the record saying that you're suggesting incompetency evaluation.
Yes.
A suggestion of incompetency, so I'll sign an order when it's presented.
So I don't need to do a formal motion, just send you an order and you'll go on my oral motion.
You're doing an open court on the record, so you can go ahead and just give me a proposed order.
I sure will, Judge. And I'll run that by Mr. Wolf.
And I guess that kind of stays all proceedings at this time. Not just in this case, but the other cases too.
Correct.
Yes, Judge. I think a suggestion of incompetency in one stays all cases.
Yeah. Okay. I believe that concludes this hearing. Unless
Thank you, Judge.
Thank you. That does conclude this hearing. Okay, Mr. Winston. Okay, this is the one I need to go through briefly. If y'all give me 1 second.
That's the guy that like jacking off on all the guards.
Who you? Where you at? Who are you? You talking about this? The guy that like jack off on the guards. Well, I want to tell you.
Hey, Wofford, Paul,
Yes.
is Lee Anthony Beecham in the jail?
Yes.
Okay. Mr. Aguilar just asked if I'd stand in for him. I want to make sure he was here.
Yeah.
With the chummo, man.
I usually have all this done before starting, but I had a lengthy morning docket, so did not occur.
You was a good diver seeing that jail. Back there, better jacket on all the guards, parachutes, everything. Piece of shit.
Can they mute the Galaxy, please?
I don't know who that is.
I don't either, but he's not saying too nice of things that everybody can hear.
And I really want to respond to him, but I know I'll get in trouble. I'm just being honest with you.
Michael, you don't say a thing. Don't say anything.
I'm not sure who he is, but if he were in the courtroom, he would have been gone too, so. Okay, we will go on the record in D40646-CR. I have counsel for both sides present, defendants present. Mr. Winston, is that your full and complete name? Michael Winston.
Yes, sir.
And Mr. Winston, you're charged with the offense of failing to comply with sex offender duty to register, and it's the court's understanding you're wishing to enter a plea of guilty to the offense alleged in the indictment. Is that correct?
Yes, sir.
And sir, do you understand what you're pleading guilty to?
Yes, sir.
All right. Ms. Martin, do you wish to waive a reading of the indictment?
Yes, Your Honor.
Record can so reflect. Mr. Winston, I just signed documents that appear to have your signature on them. They're written waivers, written plea admonishments, a waiver of your right of appeal, a judicial confession, and an evidence discovery log. Did you sign these documents, sir?
Yes, sir.
And did you understand, sir, all the documents you signed?
Yes, sir.
Did your attorney go over them with you?
Yes, sir.
You understand, sir, you have many rights in this case, and one of which is the right to have a jury trial, and you're waiving that right. Do you understand that?
Yes, sir.
You also, sir, have a right to have the same jury assess punishment should you have been found guilty. You understand that?
Yes, sir.
This is a third-degree felony, sir. It carries a range of punishment anywhere from 2 to 10 years in the Texas Department of Criminal Justice Institutional Division and a fine not to exceed $10,000. You understand the range?
Yes, yes, sir.
It's the court's understanding, sir, that you have, let me go back. Are you a citizen of the United States? Did I ask you that?
No, sir, but yes, I am.
Okay. Let me put. I'm having some issues with the Zoom. Okay. And so, sir, it's my understanding you've entered into a plea agreement with the state through your attorney. Is that correct?
Yes, sir.
Now, the court will not agree to be bound by the plea agreement. It does, however, if the court follows the plea agreement, it does cut off your right of appeal except by permission of the court. Do you understand that?
Yes, sir.
Are you entering your plea of guilty, sir, freely and voluntarily?
Yes, sir.
Do you understand, sir, the consequences of your plea of guilty here this afternoon?
Yes, sir.
Your attorney is Miss
Sir.
Martin. Are you satisfied with her representation?
Yes, sir.
And Ms. Martin, your client, he certainly appears at this time to be sane and mentally competent. Is there anything your client said or done that would cause you to believe otherwise?
No, Your Honor, I believe he is sane and competent.
Court this time will find the defendant is sane and mentally competent. Court will find the defendant has freely and voluntarily entered his plea of guilty, that he understands the consequences of his plea of guilty. The court will accept that plea of guilty and find the defendant guilty should the evidence prove him guilty. I have in front of me states 1, a judicial confession signed by the defendant. Is the state seeking to have that exhibit admitted?
Yes, Your Honor. State would offer states 1.
No objection, Your Honor.
It's admitted. Anything further from either side?
State rest.
Defense rest, Your Honor.
State have a recommendation?
Yes, Your Honor. Based on the defendant's plea of guilty and the evidence introduced, we're asking the court to find him guilty of the offense alleged in the indictment, sentence him to a period of 5 years of incarceration. Are we on the first case or the revo? I'm sorry.
We're on the new case.
I'm looking at the wrong judgment. I'm getting myself confused. All right. We're asking the court to find the defendant guilty of the offense alleged in the indictment, sentence him to a period of 5 years of incarceration in the Institutional Division of the Texas Department of Criminal Justice, assessing $290 in court costs. The defendant is entitled to credit against this judgment for 216 days previously served.
That's it.
Okay. Ms. Martin, is that you and your client's understanding?
Yes, Your Honor. Mike, let me just explain to Michael. Michael, we counted all the days up with you, and this is the new case, and that is how many you're entitled to.
So I'm not gonna get it while they're for in the past.
This
We're
is the
not
new case.
We're not through the case yet, sir.
This is the new case.
Okay, I understand.
Okay, so and that's your agreement, Ms. Martin, you and your client's agreement?
Yes, Your Honor.
All right, sir. In this cause number D40646, the court will find you guilty of the offense alleged in the indictment. It's the judgment of the court, sir. You're sentenced to 5 years in the Texas Department of Criminal Justice Institutional Division with court costs to be assessed. Any reason why sentence should not be pronounced?
No, Your Honor.
All right, sir. You are sentenced to 5 years in the Texas Department of Criminal Justice Institutional Division. You are remanded to the custody of the sheriff, who will transport you to the appropriate facility, begin serving out the sentence. This sentence begins today. You are given credit on this sentence of 216 days and any day thereafter you're awaiting transport. This will run concurrently, sir, with any other sentences you may receive out of this court. In this particular case, sir, you've waived your right of appeal. We'll go on then to D4063. I'm sorry. I got too many files up here. Strike that last number, D40185, State versus, again, Michael Winston. And again, I have counsel for both sides present, defendants present. Mr. Winston, is that your full and complete name?
Yes, sir.
And sir, are you the same individual that was placed on community supervision by this court back in June 2020 for the offense of failing to comply with sex offender duty to register?
Yes, sir.
At that time, the court found you guilty, sentenced you to some period of time in TDC, but probated that for a period of 8 years. The state has filed a motion to revoke probation, alleging that you violated terms and conditions of probation. Is that correct?
Yes, sir.
And the court understands, sir, you do wish to enter a plea of true to the allegations in that motion.
Yes, sir.
All right. Are you doing this freely and voluntarily?
Yes, sir.
And do you understand, sir, the consequences of pleading true this afternoon?
Yes, sir.
All right. Ms. Martin, do you wish to waive a reading of the motion?
Yes, Your Honor, we waive.
Record can so reflect. Mr. Winston, I do have documents that appear at this time to have your signature on them. They're written waivers and stipulations on revocation and probation. There's a judicial confession and a waiver of your right of appeal. Did you sign these documents?
Yes, sir.
And did you have an opportunity to discuss these documents with your attorney?
Yes, sir.
And she did go over them with you. Is that correct?
Yes, sir.
All right. And Mr. Winston, you understand you have a right to have a contested hearing in this case, and you're waiving that right.
Yes, sir.
You understand that you're waiving that right and you've entered into a plea agreement with the state. Is that correct?
Yes, sir.
All right. Again, Ms. Martin's your attorney on this case. Are you satisfied with her representation?
Yes, sir.
Ms. Martin, your client again appears sane and mentally competent. Anything he has said or done that would cause you to believe otherwise?
No, Your Honor.
Court this time will find the defendant is sane and mentally competent. Court will find the defendant has freely and voluntarily entered his plea of true, that he understands the consequences of his plea of true. The court will accept that plea of true and take appropriate action based on the evidence. I have in front of me states 1, a judicial confession signed by the defendant. Say seeking to have that exhibit admitted.
Yes, Your Honor, we'll offer states 1.
No objection, Your Honor.
It's admitted. Anything further from either side?
State rest.
No, the defense rests, Your Honor.
They have a recommendation.
Yes, Your Honor, based on the defendant's plea of true and the evidence introduced, we're asking the court to find the allegations in our motion to be true and proceed to revoke the defendant's community supervision. However, we ask that the court reform the judgment from a sentence of 10 years to reflect a punishment of 5 years in the institutional division of the Texas Department of Criminal Justice, carrying forward any assessed court costs, fines, etc., that were originally ordered. The sentence is to run concurrently with the sentence previously handed down in cause number D40646CR. And in this case, the defendant is entitled to 216 days of credit against the judgment.
All right. And I'm sorry, Mr. Wolf, what was the number of days?
216, Your Honor.
216.
Correct.
Okay. And Ms. Martin, is that you and your client's understanding in this case?
It is my understanding, and I want him to understand, when we did calculate 2 different numbers. We calculated 216 and we also calculated a higher number. But when I went back and looked at the probation that he took last year, it did use those days as a condition of the community supervision. So those were not allowed. So he is only eligible, to our knowledge, to 216 from the day he's been in there this time.
Yes, definitely. If that was a condition, then okay. Based on the evidence, the court will grant the state's motion to revoke probation. It's the judgment of the court that Mr. Winston is sentenced to 5 years in the Texas Department of Criminal Justice Institutional Division with any outstanding fines, court cost fees to be assessed. Any reason why sentence should not be pronounced?
No, Your Honor, not that I'm aware of.
Mr. Winston, you are sentenced to 5 years in the Texas Department of Criminal Justice Institutional Division. You're remanded to the custody of the sheriff who will transport you to the appropriate facility, begin serving out the sentence. The sentence begins today. You are given credit on the sentence of 216 days. Any day thereafter, you're awaiting transport. This does run concurrently with the other sentence you've just received from this court. Okay?
Yes, sir. Can I ask you a question? You said I had 16 days on this case right here, right? I mean,
No.
on the last case?
I said 216.
216, Michael.
On the last case or this one?
Both of them.
Together? All right.
Yes. Okay. On both of them, you have 216 days credit from today backwards.
Okay.
Okay.
All
Yes,
right.
ma'am. Thank you.
In this case, you've waived your right of appeal. That concludes this hearing, or both of these hearings. Sir, the bailiff will come over here at some point this afternoon and get your prints on the judgments, okay?
Yes, sir. Thank you.
All right, good luck to you, sir.
You too.
Good luck, Mr. Winston. Thank you, Judge.
Thank you.
Mr. Wolf.
Mr. Martin, Rocky Martin.
Yes, sir, I'm here.
That's how much you get in per case. You get 216 on.
Can y'all hear me okay?
Yes, sir.
Okay, great. Thank you, Your Honor.
Okay, this is cause number D40632. State versus Rocky Andrew Martin. Counsel for both sides is present, defendant's present. This is a status hearing. Has discovery been completed?
Judge, Mr. Martin was arrested for possession of a controlled substance, penalty group 1, less than a gram, as well as forgery of a government document money. Allegedly, he was trying to pass a counterfeit $100 bill. I've received some discovery on the PCSPG1, but I haven't received any discovery at all on the other case. In fact, I don't even know if it's been indicted or if the state intends to indict it. And speaking also on the discovery for the state jail drug case, I'd note, and I don't know if Mr. Wolf has had a chance to notice this, and I know he inherited this case, but I'd note that there actually hasn't not been any laboratory analysis done. The only document I have is from the Waco Crime Lab saying that this case was forwarded to a private lab called NMS Labs, and that DPS closed the case without analysis. So if that is all the state has, then yeah, I have all the discovery. If they ended up getting a lab report from that private lab, then I don't have that. I also don't believe I have a plea offer on this case either, but
Okay.
that's where we're at from the defense.
All right.
It was a rather exhaustive list. I'll try to take them point by point. I'll work backwards. It'll be easier. I do have from NMS Labs the lab results. They were apparently scanned into our system back in April. I don't know why Mr. Beecham did not get them, but I will remedy that today. He's written me previously to ask both about the offer in this case and whether or not we intend to make one. I will tell him that we will make an offer in this case. As far as the case concerning the forgery of the $100 bill, I can only tell him that I'm looking into it, but the last notes that I have say that it was ready for grand jury, and that was done back in 2020. So I'm going to have to follow up on that to figure out where exactly the hangup is on that case, and I will reply in due course on that one. But I will get him the discovery that he's missing and an offer by the end of the week, which will be tomorrow.
Sounds good. I also need the scheduling order. Do we have that?
Mr. Martin is not living in Corsicana anymore, and I've emailed that to him, but I'm not sure what his technological capabilities are, but I am working on that for you, Judge.
Okay.
Does have the order and he is aware of it.
Mr. Martin, you're gonna need to get it to your attorney pretty quick, okay?
Yes, sir.
You-
I got the document today
Okay.
and I was looking, I downloaded it and I'm going to see if the document itself will allow me to e-sign it. If it does, I'll do so. If not, then I'll get it printed and fax it over to him.
Sounds good.
10-4. Thank you, sir.
Judge, just so the court's aware too, I don't know if Mr. Wolf has an opinion on this, but I personally believe that the forgery case needs to be tried first, not only because it was the first arrest in time, but also because it's a third-degree felony, whereas this is the state jail case. I think that depending on the outcome of the forgery case, we may be able to kill two birds with one stone, but I can't speak for the state. They were not out of the same incident. They were very close in time to each other, but they weren't out of the same incident. So I don't think it would be appropriate to try them at the same time. But for whatever reason, the Dixon regime, I think, indicted them in a nonsensical way.
Okay.
I'd
And
love to do it.
obviously, that's up to the state to decide whether to present it to the grand jury or not. So all I got is what I have is in front of me. So I believe that concludes this hearing.
All right. Thank you, Judge. Rocky, you can sign off now.
Okay, thank you, sir. Y'all have a good day, Jim.
You too, sir. Lamar Albert.
Judge, he submitted the status form, and Ms. Romer took a picture of the scheduling order, and she's going to get that in.
Okay.
Sure of it?
All right. Let me go to Roy White. This is a plea as well.
That's correct, Your Honor.
Let me just go through the plea packet here.
Your Honor, if the state can have a minute, I need to step out. I think Ms. Schumer is going to take over for the plea.
That's fine.
Thank you, Judge.
Would you go get that plea for me? I apologize for my appearance, Your Honor. I'm working on an appeal, did not realize I was going to be in here today.
Well, I'll be honest, right now I can't see you because I'm in e-file, so I hate that you don't look right, but
I know. Thank you.
Some people have appeared in my courtroom recently laying in bed, so hey,
At least I'm upright.
yeah. And
Which
smoking a cigarette at the same time. That was a good sight. I remember that one.
Which case are we on, Your Honor?
Mr. Sipes's case with Roy B. White.
Okay.
Mr. White is present. And okay.
Mr. White, go ahead and unmute and speak up just so the court can hear you.
Where's Mr. White? Oh, you'll have to unmute yourself, sir.
Can you hear me now?
Yes, sir. All right.
Hello?
Yes, I can hear you, sir. Can you hear me?
I can hear bits and pieces, yes, sir.
All right. We will go on the record and cause number D40552, State versus Roy B. White. I have counsel for both sides present, defendants present. Mr. White, is that your full and complete name?
Yes, sir.
And Mr. White, you're charged with the offense of possession of controlled substance, penalty group 2, under a gram, and it's the court's understanding you're wishing to enter a plea of guilty. Is that correct?
Yes, sir.
And sir, you do understand what you're pleading guilty to. Is that correct?
I believe I do. Yes, sir.
Okay.
For the 3 years adjudicated probation.
Yeah, but I mean, you understand the offense that you're pleading guilty to.
Yes, sir.
Okay. And all right, Mr. Sipes, do you wish to waive a reading of the indictment?
Yes, Your Honor.
Record can so reflect. Mr. White, I have documents that appeared at this time to have your signature on them. They are written waivers, written plea admonishments, a waiver of your right of appeal, judicial confession, and an evidence discovery log. Did you sign these documents?
Yes, sir.
Did your attorney go over these documents with you?
I'm sorry, I couldn't hear that last part.
Did your attorney, Mr. Sipes, go over the documents with you?
Yes, sir.
Did you understand everything you signed, sir?
Yes, sir.
You understand, sir, you have a right to have a jury trial in this case, and you're waiving that right.
Yes, sir.
Also, sir, if you were found guilty, you'd have a right to have the same jury assessed punishment. Do you understand that?
I think he just froze, Your Honor.
Yeah. Mr. White, do you understand if you were found guilty by a jury, you would have a right to have the jury assess punishment? You'll have to unmute yourself.
Sorry.
You understand if a jury found you guilty, sir, you would have a right to have the same jury assessed punishment.
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
This is a state jail felony, sir. It has a range of punishment anywhere from 180 days up to 2 years in state jail and a fine not to exceed $10,000. You understand the range?
Yes, sir.
Can you state that again, sir?
Yes, sir.
I think I hear what you're saying, but it's very muffled. You might need to move to.
Yes, sir.
Okay. Yes, sir. Your attorney. Now we lost him.
I know you will be glad when we go back to court appearances. Oh,
Yeah.
lost everybody.
Looks like he's logging back in on the bottom right of my screen.
Yeah, but that's under another number. I don't know what it is. Leslie, what was the last thing I asked him?
Hold on. It's a state jail felony, sir, and it's range of punishment anywhere from 180 days up to 2 years in the state jail and a fine not to exceed $10,000. Do you understand the range?
Did he say yes or no?
Yes, ma'am.
Yes, yes.
You got yes. Okay. Sir, do you understand? Are you pleading guilty, sir, freely and voluntarily?
Yes, sir.
Do you understand the consequences of pleading guilty?
Yes.
Your attorney is Mr. Sipes. Are you satisfied with his representation?
Yes.
And Mr. Sipes, your client certainly appears sane and mentally competent. Is there anything he said or done that would cause you to believe otherwise?
No, Your Honor, I believe Mr. White to be sane, mentally competent, to stand trial, and understands the proceedings before him.
Court this time will find that Mr. White is sane and mentally competent. Court will find that he's freely and voluntarily entered his plea of guilty, freely and voluntarily, he understands the consequences. The court will accept that plea of guilty and find the defendant guilty should the evidence prove him guilty. Or consider deferring a finding of guilt. I have in front of me states 1, a judicial confession signed by the defendant. Is state seeking to have that exhibit admitted?
Yes, Your Honor.
Any objection from the defense?
Your Honor, before the court accepts that, I would like to ask Mr. White a couple of questions just to make sure that the record's clear on this issue.
Okay, so you're calling your client?
Yes, Your Honor.
Mr. White, could you raise your right hand and I'll go ahead and swear you in? Do you swear or affirm the testimony that you give in this case will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Mr. White, well, let me do this. We can go off the record, Leslie.
Okay.
Mr. White, let me get you to call a phone number. You can get off of your, but you're going to call this number. Do you have something to write with, sir?
1 second. I have to step back in my RV. 1 second.
Okay.
I can text it to him, Your Honor.
Do what?
Okay.
I said I can text it to him if that helps.
Yeah, that'd be good too. I'm sorry, I forgot you can do it. Just probably easier than I can. Your attorney's going to send you a phone number to call, sir. Okay, and then call that and put the code in, and then you won't have to be on your video. I think that's what's slowing it down.
Yes, sir.
Okay. What about now, sir? Can you hear me?
I can hear you, yes, sir.
Yeah, yeah. Go ahead and hang up, sir, and call the number your attorney just sent to you.
Yes, sir. I will. Yes, sir.
Okay, thank you. We'll wait for
Let
you.
me. I'm trying to.
Mr. Sipes, I think I'm just going to remove him, so that'll kind of help him hang up.
Yes, Your Honor.
I don't know how many courts have done remote voir dire. I can't imagine doing that.
The 40th here did a civil trial a couple of weeks ago. And I think they did everything in person. The jury was given the choice if they wanted to space out throughout the courtroom or just set up in the jury box. I believe it was a 2-day trial, and they all just said, you know, we're fine, just set up in the jury box.
Yeah, that's kind of what I think is about to occur. Let's see if this is your client now. Mr. White, you'll just have to unmute your phone if that's you.
Hello?
Yeah, are you Mr. White?
Yes, sir.
Okay, yeah, much better. We'll come out of recess, and I think, Mr. Sykes, you had called your client, and you may proceed.
Mr. White, we've met regarding your case and discussed your case on multiple occasions. Is that correct?
Yes, sir.
And the big issue that I kept talking to you about was you're charged with tetrahydrocannabinol. Is that correct?
Yes, sir.
And I explained to you that the definition of tetrahydrocannabinol had changed back in 2019, and the state is required to prove that there's at least a 0.03% of tetrahydrocannabinol contained within that substance. Do you recall those conversations?
Yes, sir.
And the lab report that was provided to us does not establish that that was in fact the case on your situation, that that the lab report that was supplied to us does not give a concentration of the tetrahydrocannabinol. Do you recall that?
Yes, sir.
But I did explain to you that there are states located, or there are laboratories located within the state of Texas that can test that. And if we went to trial, it was possible that the state could send it to one of those labs to be tested, correct?
Yes, sir.
And so I have explained that to you thoroughly. You understand that we're accepting this plea, even though the lab reports does not establish definitively that this is tetrahydrocannabinol with a 0.03% concentration, correct?
Yes, sir.
Okay, nothing further, Your Honor. I just want to make sure the record was clear.
Okay. Mr. Schumer, any questions of the witness?
No, Your Honor.
All right. And I do have states one, a judicial confession signed by the defendant. States he can have that exhibit admitted.
Yes, Your Honor.
No objection, Your Honor.
You know, this plea's kind of taking a little bit longer due to technical difficulties. Mr. White, did I ask you if you were satisfied with your attorney?
Yes, sir.
I'm sorry?
Yes, sir.
Okay. All right. So it's been admitted. State have anything further, defense have anything further until we get to the recommendation?
No, Your Honor.
Defense, Your Honor, at this point.
Okay. State have recommendation.
The state's recommendation is deferred adjudication for 3 years, a fine of $250 plus the $290 court cost, $180 reimbursement to the Texas DPS Austin Crime Laboratory, 40 hours of community service, hair strand test, substance abuse outpatient treatment as directed by CSCD, ADAC, and DOEP.
Okay. What was the fine amount?
$250.
And Mr. Sipes, is that you and your client's understanding of the recommendation?
Yes, Your Honor.
This time Mr. White, you understand you have a right to petition the court in the future for an order of non-disclosure.
Yes, sir.
All right, this time the court will make a finding the evidence substantiates finding you guilty of the offense. However, the court will defer a finding of guilt for a period of 3 years. During this 3-year period, sir, you are placed on community supervision where you are ordered to comply with terms and conditions of probation. Do you understand that?
Yes, sir.
Mr. White, do you read and write the English language?
Yes, sir.
And do you live here in Navarre County?
Yes, I do.
All right, you'll be reporting to an officer here in Navarre County. You understand the court's not finding you guilty this afternoon?
Yes, sir.
All right. Time, sir, I'm going to complete this hearing, and if I'll find that you have waived your right of appeal at this time, that does conclude this hearing. You'll need to come to the courthouse, sir, to get your print on the deferred order that I've just signed, and you'll also get direction from Ms. Sanchez here in a moment of how to, when and where to go.
Yes, ma'am. Yes, sir. Sorry.
All right, Ms. Sanchez.
Yes, hi, Mr. White. May I have your phone number, please?
903-493-0266.
Okay. I'll give you a call here shortly. Thank you, sir.
Thank you.
All right, sir. Good luck to you.
Yes, sir. Thank you.
All right. I guess that's it for you, Mr. Sipes, isn't it?
It is. Thank you, Your Honor. I have excused.
Yes, have a good day.
Your Honor,
Yes, ma'am.
who is our court reporter today?
Leslie Kirk.
Leslie, okay. I've just, in this doing this appeal, I have found that it is advantageous to know who the court reporters are in case you need to get a copy of something.
Yeah, that always helps. But
I mean, Leslie's always good about knowing who's there when she's not, but
she does know that. Isn't that right, Leslie?
I'll try.
Okay. So Sean Browning. looking for Mr. Browning's stuff in e-file. And this is 1 year in state. Is this a 1 year state jail?
Yes, Your Honor, it's a revocation. 1 year state jail and 99 days credit, I believe.
Okay.
Yes, Your Honor, 99.
Yeah, 99 days. I was trying to find it on the judgment there for sure.
Almost done signing this.
Like that was just an inmate at the bottom.
Okay. We'll go on the record and call the D40351, State versus Sean Michael Browning. I have counsel for both sides present, defendants present. Mr. Browning, is that your full and complete name?
Yes, sir.
And sir, are you the same individual the court placed on community supervision back on September 3rd, 2020?
Yes, sir.
The court at that time found you guilty and placed you on probation.
Yes, sir.
Since that time, the state has filed a motion to revoke probation, alleging that you violated terms and conditions. Is that correct?
Yes, sir.
And it's the court's understanding, sir, you're wishing to enter a plea of true to those allegations. Is that correct?
Yes, sir.
And are you doing this freely and voluntarily?
Yes, sir.
And do you understand the consequences of pleading true?
Yes, sir.
All right, Mr. Beecham, do you wish to waive a reading of the motion?
Yes, Your Honor, we've reviewed it.
Record can so reflect. Mr. Browning, I have documents that appear to have your signature on them. They're written waivers and stipulations on revocation and probation. There's a judicial confession and a waiver of your right of appeal. Did you sign these documents?
Yes, sir.
And your attorney, Mr. Beecham, went over them with you. Is that correct?
Correct, sir.
Did you understand everything you've signed?
Yes, sir.
You understand you have a right to have a contested hearing, sir, and you're waiving that right.
Yes, sir.
Your attorney is Mr. Beecham in this case. Are you satisfied with his representation?
Yes, very.
All right. And Mr. Beecham, your client certainly appears to be sane and mentally competent. Is there anything that your client has said or done that would cause you to believe otherwise?
No, Your Honor, he's sane and competent.
Court at this time will find the defendant. Court will find the defendant is sane and mentally competent. Court will find the defendant has freely and voluntarily entered his plea of true, that he understands the consequences of his plea of true. The court will accept that plea of true, take appropriate action based on the evidence. I have in front of me state one judicial confession signed by the defendant. State seeking to have that exhibit admitted.
Yes, Your Honor.
No objection.
It's admitted. Anything further from either side?
No, Your Honor.
No, Your Honor, not at this point.
All right. State have a recommendation.
The state's recommendation upon the pleading of true, 1 year state jail, previous fine of $500, previous court cost of $290, previous $180 reimbursement to Texas DPS Crime Lab with 99 days credit.
Okay. And Mr. Beecham, is that you and your client's understanding?
Yes, Your Honor, that is our deal. I would like to note for the court that Mr. Browning is indigent, and given that he's just accepted a deal to go to state jail for a year, I'm not certain how he'll come up with the money to pay the past due fines, but the court will trust the court's judgment on that particular point.
How much credit does he have?
I'm sorry, Judge, your audio is, it might just be me, but your audio is kind of bad.
How much credit does he have?
99 days.
I've only heard 99, 99 times, so I should remember that. Okay, based on the evidence, the court will grant the state's motion to revoke probation. It's the judgment of the court that he is sentenced to 1 year in a state jail facility. I will waive the attorney's fees based on its indigency. Fines and court costs will remain. Any reason why sentence should not be pronounced?
No.
No, Your Honor.
All right, sir, you are sentenced to 1 year in a state jail facility. You remain in the custody of sheriff, who will transport you to the appropriate facility, begin serving out the sentence. The sentence begins today. You are given credit on this sentence, sir, of 99 days. And any day thereafter, you're awaiting transport. Also, the court will make a finding, sir, that you are presumptively entitled to receive diligent participation credit if and when that's received by the court. Do you understand?
I appreciate that, and yes, I do understand.
Okay, sir. In this case, you've waived your right of appeal. That concludes this hearing. The bailiff will come
Thank
over
you.
here and get your prints on the judgment, okay, sir?
Okay.
Good luck to you.
Good luck to you, Sean.
Whenever the bill comes out.
Judge Mabby, well, no, I'm sorry. I'm standing in for Mr. Aguilar. Never mind.
I saw him here earlier.
Well, he's logged in, but he is in some kind of meeting where he asked if I could step in, and he's mostly logged in case there's a problem.
Oh, yeah. Okay, yeah, Mr. Beecham, and meet Mr. Beecham.
Hi, Mr.
Yes,
Beecham.
sir.
Are you Lee Anthony?
Yes, sir.
Hey, I hope your attorneys discussed this with you. He has a conflict right now. He has to try to be in two places at once. So he asked me to step in and handle this plea for him. Is that okay with you?
Yes, sir.
All right. He's told me what the plea offer is and all that, so I think we're okay to go forward if you're comfortable with that.
Yes, sir.
All right.
Okay, so we'll come out of recess and cause number D40917, State versus Lee Anthony Beecham. And I have Mr. Beecham present, the defendant, and we got names that sound the same but spelled differently. And so I'll try to make this as clear as I can.
For the sake of the record, just call me Cody for the duration of this proceeding.
Okay, so the record's clear. Cody Beecham is the attorney standing in for Joseph Aguilar, who represents Mr. Beecham. And to make it even clearer, Mr. Beecham, the attorney, will be known as Cody through this proceeding. All right. So,
Yes, sir.
Mr. Beecham, when we left off on the 8th, you indicated to the court that you did not understand the documents that you had signed with Mr. Aguilar. Is that correct?
Yes, sir.
And then I think Mr. Aguilar said he would come see you, and either that day or yesterday, I'm not sure when, but
Yes.
he in fact comes to you, sir.
Yes, sir.
And after speaking to Mr. Aguilar, do you understand now all the documents you signed?
Yes, sir.
Okay. And I'm assuming that Mr. Aguilar will go over those documents with you, is that correct?
Yes, sir. Yes, sir.
Okay. And do you understand, you do, and just so it's clear, you do understand all the documents you signed?
Yes, sir.
Okay. You understand, sir, that you are waiving your right to have a jury trial?
Yes, sir.
Do you understand you're also waiving your right to have the same jury assess punishment should you have been found guilty?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
This is a, I can't remember. This is, I think, based on the enhancements it makes, and someone will correct me if I'm wrong, a second-degree felony.
Correct.
Second-degree felony punishable anywhere from 2 to 20 years in the Texas Department of Criminal Justice Institutional Division, and a fine not to exceed $10,000. You understand the range?
Yes, sir.
Now, the court understands that you have worked out a plea agreement with the state through your attorney. Is that correct?
Yes, sir.
The court will not agree to be bound by the plea agreement. However, if the court follows the plea agreement, it does cut off your right of appeal except by permission of the court. Do you understand that?
Yes, sir.
Are you entering your plea of guilty freely and voluntarily?
Yes, sir.
Do you understand, sir, the consequences of your plea of guilty?
Yes, sir.
Your attorney is Mr. Aguilar, and are you satisfied with his representation?
Yes, sir.
The attorney present in the courtroom with you, Cody, is standing in for Mr. Aguilar. Are you satisfied with Cody's representation of you during the remainder of this hearing?
Yes, sir.
Mr. Cody. Cody, Mr. Aguilar's client certainly appears to be sane and mentally competent. Is there anything that his client has said or done in your presence, or that Mr. Aguilar has relayed to you about his sanity or competency that would cause you to believe otherwise?
Mr. Aguilar has told me that he believes that Mr. Beecham is sane and competent. And I have, based on my observations and interactions with him, I agree. I think he's sane and competent.
All right. The court at this time will find that Mr. Beecham is sane, mentally competent. The court will find the defendant. Also find that Cody Beecham is sane and mentally competent, just in case he needs a confidence booster. I will find that Mr. Beecham has freely and voluntarily entered his plea of guilty, that he understands the consequences of his plea of guilty. The court will accept that plea of guilty and find the defendant guilty should the evidence prove him guilty. I do have in front of me states 1, a judicial confession signed by the defendant, state seeking to have that exhibit admitted.
We are, Your Honor.
No objection. It's admitted. Anything further from either side at this phase?
No, Your Honor.
No, Your Honor.
State have recommendation.
State's recommendation upon a pleading of guilty and finding of true on the enhancements, 8 years TDCJ, $290 court cost, and 187 days total jail time credit.
Okay. And Mr. Cody, is that you and your client's understanding, or you and Mr. Aguilar's client's understanding?
That's what Mr. Aguilar relayed to me as the offer. Yes, sir.
All right. Based on the evidence, the court will find the defendant guilty of the offense alleged in the indictment. The court will find the enhancement paragraphs to be true. The court will finding him guilty of that and the true will accept the plea agreement of 8 years in the Texas Department of Criminal Justice Institutional Division with court costs to be assessed. Any reason why sentence should not be pronounced?
No, Your Honor.
No, Your Honor.
Mr. Beecham, you are sentenced to 8 years in the Texas Department of Criminal Justice Institutional Division. You are remanded to the custody of sheriff, who will transport you to the appropriate facility to begin serving out this sentence. The sentence begins today, sir. You are given credit on this sentence of 187 days and any day thereafter that you're awaiting transport, okay?
Yes, sir.
All right, sir. In this case, you've waived your right of appeal. That concludes this hearing. The bailiff will come over and get your prints here either today or tomorrow, sir, okay?
Yes, sir.
Good luck to you, sir.
Good luck to you.
Thank you. Well, let's see. We'll call you back up again. All right? Yeah, it'll be today.
Judge, may Beecham, the lawyer, be excused?
Yes, Beecham, the lawyer, can be excused.
I'll tell you, it's a little nervy listening to someone named with the same last name as you get sentenced to jail time.
But you were found sane and mentally competent, though. That'll make you feel good.
I'd want to be found insane and incompetent if I were in the hot seat. That's just me.
I understand. Well, Cody, the attorney, I may call you later on about administrative issues.
That's fine, Judge.
So thank you.
All right.
Appreciate it.
Yes, sir. You have a good one.
You too.
Judge, I think that's it for the jail.
Okay. Was that you passing by me on the street corner the other day and I got a little nervous?
Yeah,
You see me start drawing?
I saw you, but I had my hand on mine too.
Well, it would have been a shootout on the east side of the courthouse steps.
Yes, it would have.
Yeah. I was getting a little nervous.
That was me. You were standing out there talking.
A former man in the military, you probably would have gunned me down in 0.3 seconds and I would not know what was going on.
I spotted you on the other corner.
I know. That's what you already had me in the crosshairs. So, all right.
I think that's it for us though over here.
Have a good day.
All right, you too, Judge.
Someone behind you there, not working. Obviously.
May I be excused, Judge?
Yes. Have a good day.
Thank you.
Bye-bye.